Stop what you are doing right now because what I am about to share with you could change everything you thought you knew about living in America. Starting in February of 2026, the United States government is implementing a sweeping set of new immigration rules that will affect millions of people across this country. Whether you are an immigrant yourself, whether you have family members who came to America from another country, or whether you are simply a concerned citizen who wants to understand what is happening in your own nation, you need to hear every single word of this video. I have spent countless hours reviewing the official government documents, speaking with immigration attorneys, and analyzing exactly what these changes mean for everyday people. And I have to tell you, some of what I discovered genuinely shocked me. The scope of these new regulations is unlike anything we have seen in decades, and the timeline is moving faster than most people realize. February 2026 might sound like it is far away, but when it comes to immigration paperwork and legal preparations, that deadline is practically tomorrow. Let me start by explaining why these changes are happening in the first place. Over the past several years, the immigration system in the United States has been under tremendous strain. Processing times have ballooned to unprecedented levels. The backlog of cases has grown so large that some applications submitted years ago are still waiting for a decision. Enforcement priorities have shifted multiple times, leaving both immigrants and government agencies struggling to keep up with constantly changing expectations. The new rules coming in February 2026 are designed to address these problems, but the solutions they offer come with significant consequences that you absolutely must understand. The first major change involves how immigration status is verified and maintained. Under the new system, immigrants will be required to participate in what officials are calling continuous verification. This means that instead of simply renewing your status at set intervals, you will be subject to ongoing checks throughout your entire stay in the United States. The government will have the authority to verify your employment, your residence, your compliance with visa conditions, and your financial situation at any time. If you fail to respond to a verification request within the designated time frame, your status could be placed in jeopardy almost immediately. Now you might be thinking that this only affects people who are not following the rules, but that is not entirely accurate. Even people who are in full compliance with their visa requirements could find themselves caught up in bureaucratic delays or paperwork errors that trigger these verification processes. Immigration attorneys I have spoken with are already warning their clients to start organizing their documentation now, months before these rules take effect, because once February 2026 arrives, there will be no grace period and no exceptions. The second major change involves family sponsorship, and this is where seniors and older Americans really need to pay attention. If you have been planning to sponsor a family member to come to the United States, or if you have a petition that is currently pending, the rules governing those petitions are about to change dramatically. The income requirements for sponsors are being increased significantly. Under current rules, a sponsor needs to demonstrate income at 125% of the federal poverty guidelines. The new rules will raise that threshold substantially, meaning many Americans who currently qualify to sponsor family members will no longer meet the financial requirements. But that is not all. The new rules also introduce what is being called sponsor accountability provisions. This means that if the person you sponsor receives certain public benefits within a specified period after arriving in the United States, you as the sponsor could be held financially responsible for repaying those benefits to the government. And these accountability measures extend much longer than they did under previous rules. We are talking about obligations that could last for years, potentially even decades after your family member arrives. For seniors living on fixed incomes, this creates an incredibly difficult situation. You want to bring your loved ones to be with you, but the financial risks involved have become much more serious. The third change that everyone needs to understand involves travel restrictions and re-entry requirements. If you are a green card holder who travels outside the United States, or if you have a visa that allows multiple entries, the rules about how long you can stay abroad are being tightened considerably. Under the new regulations, extended absences from the United States will trigger automatic reviews of your immigration status. If the government determines that you have abandoned your residence in the United States, you could lose your status entirely, even if that was never your intention. I know many seniors who split their time between the United States and their country of origin. They want to maintain connections with family abroad while still keeping their American status. Under the new rules, that balancing act becomes much more precarious. The government will be looking more closely at factors like where you pay taxes, where you maintain a home, where your bank accounts are located, and how long you spend in each location. If the totality of your circumstances suggests that your primary residence is outside the United States, your green card could be at risk. The fourth major change involves the public charge determination, and this is perhaps the most concerning change for seniors and retirees. A public charge determination essentially asks whether an immigrant is likely to become primarily dependent on the government for support. Under the new rules taking effect in February 2026, the factors considered in this determination are being expanded and weighted differently. Age will now be considered more heavily than before. Receipt of any public benefits, even those that immigrants are legally entitled to receive, will be counted against applicants. Health conditions that could require expensive treatment will receive additional scrutiny. What this means in practical terms is that older immigrants, people who are closer to retirement age or already retired, will face much greater obstacles in adjusting their status, renewing certain visas, or bringing family members to join them. The system is essentially being designed to favor younger, healthier immigrants with higher earning potential while creating barriers for everyone else. If you are a senior who has been planning to adjust your status, or if you have family members who are older and hoping to immigrate, February 2026 represents a critical deadline. Applications submitted before that date will be processed under the current rules, but anything filed after could be subject to these much stricter standards. Now, I want to talk about what you can do to protect yourself and your family before these changes take effect. The first and most important step is to consult with a qualified immigration attorney as soon as possible. I cannot stress this enough. Immigration law is incredibly complex, and the consequences of making mistakes are severe. An experienced attorney can review your specific situation and help you understand exactly how these new rules will affect you. They can also help you identify opportunities to file applications or petitions before February 2026 so that you are processed under the current, more favorable rules. The second step is to start gathering your documentation now. If you are going to need to prove your income, your employment history, your residence, your family relationships, or your compliance with visa requirements, do not wait until the last minute to locate those documents. Start putting together a comprehensive file that includes tax returns, pay stubs, utility bills, lease agreements, birth certificates, marriage certificates, and any other paperwork that might be relevant to your immigration status. Having everything organized and ready to go will make the entire process much smoother and reduce the risk of delays or errors that could jeopardize your case. The third step is to carefully evaluate any travel plans you have between now and when these rules take effect. If you are a green card holder or visa holder who is planning to travel abroad, think carefully about how long you will be gone and how that might be perceived by immigration authorities. Consider whether it makes sense to postpone or shorten any extended trips until you have a better understanding of how the new re-entry requirements will be applied. The last thing you want is to leave the country for what you think is a routine visit to family and then discover that you cannot get back in. The fourth step is to understand exactly which benefits you and your family members are receiving and how those benefits might affect future immigration applications. Many immigrants are entitled to receive certain benefits, and there is nothing wrong with claiming benefits that you have earned and are legally qualified to receive. However, under the new rules, receipt of those benefits could be held against you or your family members in ways that were not previously the case. Knowing exactly where you stand will help you make informed decisions about what benefits to claim and what documentation you need to maintain. I also want to address something that I know many of you are worried about, which is the enforcement side of these new rules. The February 2026 changes are not just about paperwork and applications. They also include provisions for increased enforcement activities. Immigration and Customs Enforcement will be receiving additional resources to identify people who have overstayed their visas, violated the terms of their status, or otherwise fallen out of compliance with immigration requirements. Data sharing between government agencies will be expanded, making it easier to identify discrepancies between what immigrants report on their immigration applications and what appears in other government databases. What this means for you is that even small mistakes or oversights from years ago could come back to haunt you under the new system. If you have any concerns about your immigration history, any questions about whether you have always been in full compliance, or any uncertainty about paperwork you filed in the past, now is the time to address those issues. Do not wait until an enforcement action forces you to deal with problems that could have been resolved proactively. For seniors specifically, there are additional considerations that you need to be aware of. Many seniors rely on programs like Medicare, Medicaid, Social Security, and various state and local assistance programs. The interaction between these programs and immigration status is becoming more complicated under the new rules. If you are not a United States citizen, you need to understand exactly how your immigration status affects your eligibility for these programs and how receiving benefits from these programs might affect your immigration status going forward. This is an area where the consequences of making wrong assumptions can be devastating, so please do not guess. Get professional advice from someone who understands both immigration law and benefits programs. I also want to take a moment to address the emotional toll that these changes are taking on immigrant communities. I have heard from so many people who are scared, confused, and uncertain about their future in America. Families who have been here for decades are suddenly questioning whether they will be able to stay together. Seniors who thought they had achieved stability are discovering that their status may be more precarious than they realized. Parents are worried about their children. Children are worried about their parents. And everyone is trying to navigate a system that seems to be changing faster than anyone can keep up with. If you are feeling overwhelmed, please know that you are not alone. Millions of people across this country are in similar situations, and there are resources available to help. Nonprofit organizations that specialize in immigration services can often provide low-cost or free consultations. Community groups can connect you with others who are facing the same challenges. And while I am not in a position to give legal advice, I am committed to keeping you informed about what is happening and what options might be available to you. Looking ahead, there are still many questions about how exactly these new rules will be implemented. Government agencies will be issuing additional guidance in the coming months, and there may be legal challenges to some aspects of the new regulations. Things could change, and I will be following this story closely to bring you updates as soon as new information becomes available. Make sure you are subscribed to this channel and that you have notifications turned on so you do not miss any important developments. In the meantime, the most important thing you can do is take action now. Do not wait until January 2026 to start preparing. Do not assume that everything will work out on its own. Do not put off conversations with attorneys or advisors because you are hoping the rules might change. The deadline is February 2026, and that date is coming whether we are ready or not. If you found this information helpful, please take a moment to like this video and share it with anyone you know who might be affected by these changes. There are so many people out there who have no idea what is coming, and the more we can spread the word, the more time people will have to prepare and protect themselves and their families. Thank you for watching, and I will see you in the next video with more updates on the changes that matter most to you and your loved ones. Stay informed, stay prepared, and most importantly, take care of each other during these challenging times.